Safety's January 21st meeting will now come to order. Will the clerk open the roll so the members can indicate their attendance? Close the roll.
Quorum's present.
Thank you. I know we've got a couple folks, couple patrons here who need to get to another committee. So without objection, I know that folks signed up, but hopefully we can just deal with their bills in an orderly fashion so that they might get to the other committee. I don't know, Doug Poindexter, you signed up first. Do you have any objection to that? Oh, wait. Okay. All right, well, let's go with, seniority's got to have some benefit, right, Kelly?
I'll get it if I can get it.
Tell us about your bills.
So, thank you, Chair. I've got actually two bills before you this morning, HB 1470 and 1471. They deal with the same issue. It's just sort of two different approaches, and they are not mutually exclusive. So both of them could be taken up, or neither if that, whatever the committee chooses on this. But 1470 is simply a bill to satisfy the reenactment provisions of a bill from last year, which dealt with firearms ordinances when hunting. This dealt with if someone owns a parcel of land and they are in two different localities. Say part of it is as in the case with what the constituents brought this to me, a portion of the land is in Franklin County, a portion of the land is in Roanoke County. However, during hunting season, those two counties have different firearms ordinances. When, for example, one could use a shotgun, the other was rifle only. And in this case, the particular constituent inadvertently stepped from one county to the other while they were out hunting on land and ended up getting cited by DGIF as a result of that because they were using a shotgun where they only were supposed to be using a rifle. So this just says that if you own that parcel of land, that you can declare the ordinances to be in place for the entire parcel that will apply to the largest portion of that parcel. So that, wherever the majority of the land is, those apply to all of your property and only your property when it crosses over the line. We needed to take a look at this. DGIF did give a report to the ACNR committee. There are some concerns with this, as there are with not doing anything. But my understanding is that they haven't taken a position on it one way or the other, and we just were hoping to clarify that. If by explanation I could go ahead and let you know about 1471, rather than giving permission to divide that, what 1471 does is just says, if you didn't make a declaration, doesn't even apply to that if you are cited, that and then could demonstrate that you actually just wandered from one side of your property to the other, that it would serve as an affirmative defense when you were challenging that in court and responding to that. So again, sort of two approaches to the same problem, and they aren't mutually exclusive. But
Thank you,
those
Doug.
are the two bills.
Is there anyone here to speak in favor or opposition to Doug and Ed's legislation? Seeing no one, I'll bring it back to the committee. Questions? Delegate Davis.
Thank you, Mr. Chairman. Delegate, if I'm looking at this properly, and we've had this in front of us before, it's kind of to prevent that gotcha moment.
Exactly.
Where you're on a parcel, you wander across into another one. Obviously, jurisdictions change, the rules have changed, and this is to kind of prevent that gotcha of someone that inadvertently does that.
Right. I mean, if you compare it to like a speed limit that changes, if you go from one zone to another when you're out on the road, there's a sign that says, the speed limit has changed.
Right.
But if you're just out in the woods and you wander, sometimes there may be a creek, there may be a fence line, but sometimes it may just be an imaginary line running through a field and you don't know which side of it you're on. So.
Thank you.
Delegate Holmes.
Mr. Chair, I'd ask the delegate if outside of firearms laws, are there other examples of selective enforcement of ordinances when you cross jurisdictional lines similar to this?
Mr. Chairman, my response would be that I don't know of anything that falls into this kind of a category. This really comes about because hunting firearms ordinances, and that's really where this comes into. It's not even specifically a firearms ordinance as much as this is a hunting ordinance. And the firearms provisions of hunting ordinances are rather unique in that they are a patchwork quilt of regulations that are out there. Most of the time, we design that so that the state agency controls that for everybody and draws the lines. But with hunting ordinances, we leave that to the individual localities, and so it literally changes arbitrarily across the Commonwealth, and so it's very, very difficult to compare it to anything else.
Any additional questions from the committee? Seeing none, committee obviously operates by motion.
Mr. Chair, I'd like to make a motion.
Delegate Homer.
Motion to lay this on the table.
It's been moved and properly seconded to table House Bill 1470. Clerk will open the roll, and members will vote on their electronic voting machines. There we go. Close the roll. Motion to lay it on the table passes by a vote of 5-3. Did you have anything else to say on 1471?
1471, again, it is simply an affirmative defense.
Mr. Chairman, speaking to the bill.
Delegate Davis.
Thank you, Mr. Chairman, I mean, this really is a case of just preventing a gotcha moment, and I know we just dispatched 70, but 71 is kind of important. I know the Delegate Hummer asked a question of does this apply anywhere else? I would challenge him to find any other opportunity in the Commonwealth where you cross over a local jurisdiction line from private property to private property, not public property to public property. And in Virginia, we have a Dillon rule. This is not one of those instances where we exercised our Dillon rule in the Commonwealth of Virginia. This is what happens when you don't. So for that reason, I would move that we report House Bill 1471.
There's a motion to report 1471.
Mr. Chair, I'd like to offer a
Delegate Homer.
substitute motion, motion to lay this on the table.
There's a substitute motion to lay it on the table. It's been properly seconded. Members, the clerk can open the roll, and members will vote on electronic voting machine. Close the roll. Motion to lay on the table passes 5-3. Thank you, Delegate Davis.
Thank you very much.
Next, Delegate Walker has to go to HWI. Good morning, Delegate Walker. There are a couple of bills that I believe are the same. Is that right, Charles?
That's correct.
So why don't we have Delegate McGuire come up? Delegate LaRock. We can, I believe we can pick these up on the block. So we can hear them all at the same time. We'll defer to Delegate Walker. Why don't you start, and then I'll give your colleagues an opportunity to say a few words if they have anything to add. Delegate Walker.
Thank you, Mr. Chairman, and members of the committee. So my bill, 596, is a bill to repeal Code 18.2-283 of the Code of Virginia relating to carrying dangerous weapons in places of worship. So I'm asking for a repeal on this particular code here. I know that this is a private property, many churches of worship and things like that. But in recent years, and just prior to our Christmas time there, we all are aware of the situation that took place in synagogues as well as other places of worship here. I attend a very large church. We have over 5,000 seats. We have one paid security guard with many entrances to our place of worship here. We have a sheriff who is also a member of our place of worship, as well as law enforcement people in our community. So what I want to do is, as a point of clarification, is to ensure that we are protected for those that want to carry. I understand this comes as a result of a church, granting certain individuals that in regards to concealed carry and other training. So we do have people that are professionally trained. So that's what I want to do, is make sure that we not only can come to a place of worship, but at the same time, if you can't feel safe in a place of worship, then where can you feel safe? So this is part of the code here, is to repeal this section as relates to code change that the commission consider that. I have two other colleagues here that have bills very similar. I think the language may be, so if they would like to address, if you would grant them permission, to hear.
Absolutely. Delegate
Okay.
McGuire, you have anything to add?
Yes, Mr. Chairman. A state lawmaker in Texas repealed a similar section of the code in September, and that allowed Jack Wilson and several others to draw a weapon and save lives in Texas. So we've got a little bit of everything written down here. This bill, I named my bill after Jack Wilson, the hero who saved lives. In a matter of seconds, lawfully used his handgun to stop a mass shooting in a church in Texas. He was there because Texas law now allows carrying a handgun into a place of worship. In Virginia now it's illegal. Unfortunately, in today's day and age, nothing is sacred, not even the Constitution, not a place of worship, not a school. People will go anywhere, anytime to implement their evil. That day in church in Texas was no different than any other, except it was a deranged shooter whose pure goal was to bring evil into the house of God, shot and killed at point-blank range 2 worshipers. As this unfolded, Jack Wilson drew his firearm and killed the shooter in seconds as he was taking aim on someone else. Now, everyone knows me in politics. I'm a big supporter of our law enforcement, big time. The men and women in uniform do great things, but they can't be everywhere. And in 2.5 seconds, he saved lives. God forbid this happens in Virginia. We are in a place where we can stop this. We can do something about it, but only if you believe that a law-abiding citizen armed with a concealed carry permit has the right to protect themselves and others in their place of worship. The person intent on doing evil in a place of worship, do you think they are worried about obeying the law? Samson?
Delegate LaRock, anything to add?
I would like to, Mr. Chairman. I think as has been mentioned, I'd just like to reinforce and emphasize that this is the state going onto private property, making a law that applies, again, private property in a place of worship during a service. So apparently it's okay to have a gun on private property when a service isn't being held, but when the preacher goes up to the podium and starts the service, this law changes something. That's the effect that it has. So very, very briefly, it really serves no compelling interest. We have examples of that Delegate McGuire just illustrated that prove beyond any shadow of a doubt that with security in the church during the service, the outcome is far better. Far better lives are saved. We have Sutherland, Texas to prove just the opposite. People were gunned down in that church that the perpetrator actually had time to circle back and kill the people who were still alive. So a man came from outside the church, heard the gunfire, and came and brought that to an end. Absolutely irrefutable proof that it is better to allow churches to control their own security. Now that doesn't mean we want to require churches to have guns. It is private property. If they choose to have a policy that says no guns in this church, no guns during service, that's fine. But it's not the government's place to make that decision for them. It also has an interesting effect in that it separates the responsibility, which is always going to be the private property owners, from the ability to control the premises. So if you have an insurance policy, let me back up one step. When people come on your property, you have an insurance policy that deals with liability, but the government is actually taking away the property owner's ability to keep these people safe. Again, completely out of bounds for the government to make these kind of decisions. The law itself is ambiguous, it's very unclear. There's 2 Attorney General's opinions. Unique instance, I think, for Attorney General Cuccinelli and now Attorney General Mark Herring agreed that a good and sufficient purpose, which is the tail end of this current law, is self-defense. However, AGs don't make laws, courts do. So it'd be very easy for a court to disagree and find someone to be in violation of the law for having carried during a service if they didn't feel that was good and sufficient cause. So a lot of ambiguity. We really just want to, I think, make it clear to churches as they meet, as they deliberate, the leaders that are making the decisions for that private property, to have the ability to say, we want them or we don't want them. This is our policy, and do so without having the uncertainty that is inserted into the situation by an ambiguous law, which dates back to the blue law days where the government banned things like gambling and consumption of alcohol on Sundays. It's very outdated and very inappropriate.
Thank you. delegates, is there anyone here to speak to House Bill 373, 596, or 1486? If in favor, step up, please
My name
identify
is
yourself.
David Noble, I'm from Providence, Georgia, and I want to support these gentlemen in this. First of all, remind the committee that we have a clause in our Constitution that separates church and state, is that correct? So where does the state come off with the ability to tell what you can do in a church? Second of all, church is private property, is that correct? Lowe's is private property, McDonald's is private property. No one in the state here has said that you can't carry a gun into Lowe's or McDonald's or any other publicly operated place. So why are you telling the people in a public place such as a church they can't carry? I agree with Delegate LaRocque. It ought to be up to the church to decide whether or not they want their constituents to have guns. We know already in one case just recently where the man had a gun, he stopped a lot of people from being killed that day. Let the churches decide, not this committee. It's not up to you, it's up to the church. It's a private institution, it doesn't belong to you. You've got bills on the table right now that allow localities to decide whether or not they want guns in their places of business. That's fine, that's part of the government, they have that right. The church has the same right to decide on their own. Thank you.
Thank you. Let's go ahead. Is this everyone that wants to speak in favor of the bill? All right, so let's put, we'll give each side 5 minutes.
Yes, sir.
Whoever's next, come on up and introduce yourself.
Morning, my name is Steve Birnbaum. I live in Arlington County. I am the head of a volunteer security team at my local synagogue, and I also support synagogues across the DMV area, Maryland, DC, as well as Northern Virginia. The police response time to the Tree of Life Synagogue, the first officer arrived 10 minutes after the start of the attack. The average law enforcement response time in the United States in an urban center is 8 to 12 minutes. In rural areas, that can get up to 25 minutes. Even in Northern Virginia, with the large departments, there are times when the departments have told synagogues when they have money to pay for off-duty officers that the department has no officers to spare or no one signed up for the detail. So there are many cases where the synagogue has no other option, if they even have the money. In a lot of cases, they simply don't have the funds to pay for an off-duty detail. A lot of these synagogues, especially the smaller ones, like the Chabad synagogues that you might remember was attacked in both Poway, California, as well as the Chabad synagogue that was attacked in India during a terrorist attack there. A lot of these synagogues, when they first start out, are in the basement of the rabbi, of his home. Several years ago, I actually had my rabbi ask me, so under the current text of the Virginia law, can I be charged and can I be arrested and charged for being in possession of a firearm in my own basement? Because his basement is a place of worship. Ultimately, I understand that there are some synagogues that don't even want paid security because they don't like firearms, they don't want off-duty officers, they don't want paid security. That's their choice. But there are synagogues that understand that law enforcement are not coming, that they're on their own for 10 minutes, if not longer, especially in rural parts of the state. So these synagogues want the ability to have their own means to protect themselves. And they don't want the ambiguity that the people that step up to protect the congregation, to protect their neighbors, heck, even a rabbi in his own home won't be arrested because of selective interpretation of a law that is so ambiguous. Delegate LaRocque, I believe, mentioned that the AGs don't make law. That's true, but what's to stop a future AG from issuing an opinion that conflicts with the standing opinion from former Attorney General Cuccinelli that simply says, okay, from now on we can't do it. And that leaves synagogues and places of worship across the state completely unprotected. So I ask you to please forward these bills. All this does, under existing law, any synagogue that does not want firearms, post a sign, say prohibited, done. The law is already in the books for a synagogue that does not want firearms on the premises, and nobody is suggesting that they should be forced to do it. But the synagogues that do want armed security or armed congregants should also not worry about running afoul of the law due to an ambiguous law. And I ask you to please allow that to happen so that we can protect ourselves.
Thank you. Got about 2 minutes left.
Morning, my name is David Decker. I'm in strong supportance of HB 373 and HB 596 and HB 1486. We need to save lives and stop mass shootings in churches, just like in Texas with Jack Wilson. 2.5 seconds to save lives versus 5 to 10 minutes of the police showing up after with mass casualties. People are clearly targeting people of faith around the country, and I'd love to be able to put an end to that by passing these bills.
Thank you. Next.
Philip Van Cleve, Virginia Citizens Defense League. We support these bills. I think Delegate LaRock did a great job presenting the information. Thank you.
My name's Robert Rink, and I'm an attender of a church in the Fredericksburg area. And my job as a deacon was to walk the halls and take care of those that would try to harm our kids and our people. The church is opening and welcoming by our definition. I've done this, been in all domestic violence, drug-addicted homes. That's my life. They come trouble to us. The elevation of what harm can happen to the folks that little old me gets to walk around is so much harm that people mentally break down in the midst of my congregation of 800 and try to care for them and stand next to them. And so I do speak on behalf of this law as someone who lives it, who wants to care for those that I have the responsibility as just a citizen of the community to be able to do so properly and provide that kind of security for us. Thank you.
Thank you. Is there anyone here to speak? Oh, I'm sorry.
Mr. Chairman, ladies and gentlemen, Bob Sadler, South Richmond. 5 days before Governor Northam was elected, members of an unarmed church in Sutherland Springs were slaughtered like fish in the proverbial barrel. Just weeks ago, a church with armed volunteers stopped a shooter in 2.5 seconds. Go ahead, stand in the way of that. Thank you.
Okay. Is there anyone here speaking in opposition to the bills? Please come up, identify yourself for the committee.
Andrew Ballard, Virginia Center for Public Safety. There's nothing in the existing law that prevents a church or any other place of worship from hiring someone professionally trained to provide security. If there is ambiguity in the language, then I would definitely support a change in the law to make that ambiguity go away. Make it clear. I'm hesitant to talk about the church in Texas. It was a clear example of someone preventing, a hero preventing a mass shooting. He was one of 2 people who were there specifically to do that. He was a very well-trained person. There were many other people in that church who had guns, and they pulled them out after the shooting was over. The first person to die was one of those 2 people. So if you're talking about having armed security, you need to have one person to take the first bullet to give the second person time to make the shot, which is what happened in that case. Thank you.
Thank you.
Good morning. My name is Lori Haas. I'm with the Coalition to Stop Gun Violence, and we oppose the bill. As the gentleman before me mentioned, the current code allows churches and places of worship to either have hired, paid, or volunteer security staff. It's all available to them under current law. We understand the effort to save lives, but our focus should be on preventing people who intend on doing harm from getting the firearm in the first place. We wholeheartedly oppose the bill. Thank you.
Mr. Chairman, members of the committee, Nikki Zamasi, Deputy Secretary of Public Safety and Homeland Security, and for all of the reasons already stated, the administration opposes the bill.
Anyone else?
Hi, I'm with the Virginia Catholic Conference, and as well for the reasons stated, we oppose these bills as well.
Your name?
Julia Sponwitz.
Anyone else to speak in opposition to the bills? Bring it back to the committee for questions. Delegate Davis.
I just have a few questions here because the word was used ambiguity, a lot of ambiguity, and it seems pretty accurate. So just for clarification, if someone can answer a couple questions. If that situation, that tragedy in Texas happened in Virginia, and you don't get 20/20 hindsight to decide whether there was good and sufficient reason. You don't get to look back. It has to be when someone showed up with a firearm, they show up with good and sufficient reason. Does someone at the church have to bring charges, or can the state bring charges absent the pastor of the place of worship?
Who's that question?
Is that some, I would, either the administration rep that just turned up, or maybe LIS, or whoever.
Sure. So can you, I apologize. Can you
Sure.
repeat your question?
So if we had the tragedy in Texas, in Virginia, we all know that good and sufficient reason does not get 20/20 hindsight. So if it was deemed that there was not good and sufficient reason, does it have to be the pastor of the church that brings charges, or can the state bring charges in its sole decision?
It's punishable as a class 4 misdemeanor, which is also very low. So the state it's not under any obligation to prosecute.
But they could.
They could, as well as the church could bring charges itself. Or you could ask for a warrant to be sworn out, or have someone from the church swear out their own warrant for it.
And follow this, Mr. Chairman, if I may.
Okay.
The place of worship, someone mentioned it could be a home. So if a synagogue, if a place of worship, whether it be for Jewish faith or Christian faith, but if something started in someone's basement, does that meet the definition of place of worship? And if so, if there happened to be a firearm in a safe in that place, is that now in?
I don't believe home would qualify as a place of religious worship as under the statute. The U.S. Supreme Court has recognized that an individual has the right to self-defense, and it is a constitutional protected space in terms of firearms and self-defense. So, to the extent that someone's home, where they live and reside, I don't think the statute could criminalize that possession of firearm in that space.
And last question, Mr. Chairman, if I may. Someone had mentioned that we have a ruling from the Attorney General on whether self-defense does classify. If charges were brought, is that like an affirmative defense? Is it a get out of jail free card? Or is it not the same weight as a law passed by the Commonwealth?
It does not carry the same weight as a law passed by the Commonwealth, but there is case law that says the Attorney General's opinion are the most persuasive authority besides another court opinion. It's also presumed that when an Attorney General issues an opinion, the General Assembly can presume to act in response to that opinion. If the General Assembly chooses not to act in response to that opinion, that even gives that opinion more authority, meaning that when the AG opinion, looking at the statute, said without good and sufficient reason, well, carrying for your self-defense is good sufficient reason, the General Assembly could have the next year or the subsequent years changed that and decided, no, we don't like what the AG said, but failure for the General Assembly to do that would lead to the argument of, look, this is good and sufficient reason because the General Assembly has failed to address the AG opinion, which is of the most persuasive authority other than a court opinion.
Any further questions from the committee?
Question.
Go
Is there a copy of the Attorney General's opinion available? Do you have one with you?
It is online.
Okay, you don't have one with you. Okay, I'll leave it.
In essence, what it amounts to is saying that self-defense is, in their opinion, a good and sufficient reason to have a weapon in a church during a service.
Seeing no further questions, I'm gonna give each of the delegates 10 seconds for the last word, if they want it.
Thank you, Mr. Chairman. As a point of clarification, I want to go back to the home situation because that's where many churches start. I'm part of a Bible group that, 15 of us get together. We praise the Lord in hymns, we read the Bible, pray. And this is language that is a place of worship. So will we not be considered a place of worship within a home?
I think he's answered the question that a home would likely not fall into the definition of a place of worship.
Okay, I just wanted to make sure that point is clarified.
Small clarification, with the Jack Wilson incident, it wasn't 2 people that pulled a gun. Video shows 7 people, and they were able to do so legally because of legal detection.
Thank you. Delegate Rock, any last words?
I would just say, at the end of the day, if you really feel that people are safer in a church during a service, unprotected, that they're not sitting ducks, then I guess you would vote against repealing this law. If you would like to make people safer, which is, I think, the common goal of all of us, then you would support this bill.
Committee operates by
Time
motion.
for discussion on the table, Mr. Chairman. I'd like to speak to the bill.
Okay, there's no motion to do anything.
I move to report the bill.
Okay, it's been moved.
Mr. Chair, I submit an alternate motion. I move to lay this bill on the table.
It's been moved and properly seconded to lay the bill on the
You have to
table.
discuss it, I guess.
Just to be clear, for the new folks, and I probably should have done this in the last bill, but opposing the motion to lay on the table means you support the bill, which in this instance is allowing firearms in churches. And if you support the motion to lay on the table, that means you don't support the underlying policy.
Point of order, Mr. Chairman. Would it also not mean that they voted against to lay it on the table? They may want to actually discuss the bill before they vote to kill the bill?
I don't think so. I think if you want to speak to the motion,
Well,
you can
Motion
do
is
that.
not debatable.
Right.
I'm sorry?
Substitute motion is not debatable.
Exactly, that's why, so if they would like to discuss the bill, they would have to vote against to lay it on the table, to allow discussion, and then vote against the report, correct?
Delegate Davis, we have spent probably 20 minutes
Ask the
discussing
questions.
whether or not people support or oppose allowing guns in churches. And so there's no more clear indication of how you feel about that underlying policy, then which button you push when we vote.
I'm sorry, Mr. Chairman, I thought I was just asking questions before, I must have got confused, sorry.
The clerk will open the roll. There's a vote on electronic voting board. Close the roll. Motion lay on the table passes 5-3. Thank you, guys. Next bill we'll take up is going to be Delegate Poindexter. Thank you for your patience, sir.
Thank you, Mr. Chairman, members of the committee. House Bill 1175. Let's explain the bill, use some brief rationale on it. Why I think this is a good bill. As hopefully you know, the current code does have penalties for use and display of firearms in certain specific felonies. Currently, Code Section 18-2-53-1 makes it unlawful to use or attempt to use or display or threaten with a firearm in committing serious felonies. Now, these are serious felonies I'm talking about this morning: murder, rape, forcible sodomy, penetration, robbery, carjacking, burglary, malicious wounding, and so forth. Violation of this section today calls for a 3-year penalty for the first offense, 5-year penalty for the second offense. House Bill 1175 simply increases the penalty for the first offense to 5 years and the second offense to 10 years. This focuses on those that create gun violence and that commit homicides. The goal really is deterrence. In other words, you're going to jail for 5 years if you use a weapon or a gun on that list of felonies I just listed. This gives our prosecutors and our police an excellent tool to use to address those people that really use guns in an illegal fashion. It focuses on gun violence itself and homicide. Now, that's the bill. I will submit to you that we know that penalties like this work. We had a huge problem in Richmond 20 and 30 years ago. And there was a concerted effort to lay 5 years on each of the first offenses and send people to jail. I'll give you some numbers. This was 1997. In the first year of an approach like this, 372 people indicted on federal charges, 440 illegal guns seized, 300 arrested, 222 held without bonds, 247 convicted, and 196 persons sentenced in the city of Richmond. So the evidence is out there. It may not totally, it won't fully solve the problem. But I would propose to the committee this morning that it will have a significant impact on homicides and violence, and gun violence across Virginia. And it won't take years. You'll see changes the first year, and moving on out to 5 or 10 years, you'll see further changes. That's the bill. Thank you for consideration.
Is there anyone here to speak in favor or opposition to the bill? Come on up, identify yourself.
Hi, my name is Dave Decker. I strongly support the bill. Thank you.
Thank you. Anybody else support it? Go ahead.
Mr. Chairman, ladies and gentlemen, Bob Sadler. I live about 15 minutes that way in a very downbeat section of the city, and I strongly support this bill.
Thank you. Anyone else to speak in support? In opposition?
Mr. Chairman, members of the committee, Andrew Goddard, Virginia Centre for Public Safety. I'd like to remind the committee that this is a secondary charge. The charge that for the underlying crime is probably the one that's going to set the sentence, which will be considerably greater than this sentence for the firearms part. And I believe that we should leave the judgment on that issue to our judges, which is what is in their job description. Thank you.
Good morning. My name is Lori House. I'm with the Coalition to Stop Gun Violence. We oppose the bill. As we know, and research shows, mandatory minimums and other sentencing minimums do not deter crime.
Mr. Chairman, members of the committee, Nikki Zamosny, Deputy Secretary of Public Safety and Homeland Security, and for the reasons already stated, the administration opposes the bill.
Thank you. Anyone else to speak in opposition? Bring it back to the committee for questions, and just so I stay straight, if you could just use you got a request to speak.
We don't do
Okay.
it.
Okay. Delegate Price, I think you said you had a question.
So, and this can be for Ms. Haas or for the patron. You were quoting that there were rates that were lowered in the 90s. Can you repeat that? What were the rates that were lowered, and how are you attesting that to mandatory minimums if you have not yet passed your bill?
The violations that I'm talking about are the felonies that I listed that's in the current code. And those include rape. Yes. Threatening a rape with a gun. Okay, or
Right.
using a rape to hold someone down.
Follow-up question, Mr. Chairman.
Delegate Price.
And the rates that you were saying, I heard 1997 in Richmond.
That's right.
What was that trajectory that you were saying that the
I do
rates
not,
were?
Mr. Chairman, I don't have a breakout of what was raped, but these are breakouts, these numbers are for the use of guns and all of those crimes including rape.
Delegate Price, I think what she's asking is, what were the numbers that you quoted, the statistics about guns, what were the arrests? You had some statistics about the
Yes,
city
I
of
did.
Richmond in
Yes, I
1997.
did. 372 indicted for federal gun violations. 440 illegally possessed guns seized. 300 persons arrested or held in state custody. 222 arrestees held without bond. 247 persons convicted, and 196 persons sentenced to 55 months of imprisonment, close to a 5-year thing, it's in there.
Further
What
questions?
would be good?
Anyone has any questions? I just have a comment that, I think this is our version in Virginia of what was or what is Project Exile. And while it may have had some effect on firearms, I think the negative